Hello, I'm bobbydalebarina of bobbydalebarina, attorney at law. And today I would like to talk to you about a few of the common myths that surround Texas family law. Now, it's just a few of the numerous ones. Before I do that though, allow me to invite you to contact me if you have a family law situation, a family law matter, if you're thinking of filing for a divorce, if your spouse has filed for divorce. Contact me, allow me to set up a consultation with you so we can discuss those unique prospects and circumstances surrounding your family law matter. Now again, a few of the common myths. The first one I encounter on a weekly basis, whether it's from my client or from the other party. Someone will say, the woman, the mother, always gets the children. Whether my client's the mother of the child or the father, I hear that on a constant basis. It's been my experience locally and nationwide that it's a little over 60% of the time that the female asking the court for custody will be awarded custody. And again, that really means the right to establish where the child lives and collect child support. But if it's 60%, then 40% of the time, the father of the child is getting that important right. What it really comes down to is not the gender of the parent asking for that right to establish domicile, it's the best interest factors and how they apply in that unique situation, that unique family, the dynamics surrounding it. So that is a common myth. Another common myth that I deal with is that property is always divided 50-50. Now, that's not true. Property is divided on a just and equitable circumstance. And that is different in every case. Because every case has unique property, has unique situations, has different income levels, has different retirement, and different compositions of the community property estate. Recently, I did an appeal out of the 14th Court of Appeals in Houston, Texas. And I did the appeal for a local lawyer who was responding to an appeal filed by the opposing party in a divorce she had just concluded. He filed the appeal. We represented the wife. The husband filed the appeal even though he got more than 50% of the community property estate. He felt that awarding her specific types of property was not just and equitable. Ultimately, after many months, the Court of Appeals affirmed the trial court decision and said, yes, the trial judge was right. The award of the property was just and equitable, that it was fair in this circumstance, that the award of that was okay. Now, the other common myth we deal with is everything is community property. Everything is subject to this just and equitable division. That's just not true. A lot of property can be considered separate property. We do have a presumption in Texas that everything as you consider it at first glance is community property, and then an attorney or a party will say, no, I got this prior to the marriage. I got this by inheritance. I got this piece of property as a result of a personal injury award or settlement for personal injury to me, not lost wages or income. That, of course, would be community property and subject to division. So everything is not community property. Another common myth is I or any party can refuse to be divorced. They can refuse to participate. In Texas, that's just not true. As long as the party, the other party who refuses to participate, is properly served, is properly given notice that this divorce is happening, then their participation is not required. One party who seeks the divorce can petition the court for the divorce, serve properly the other party, set a court date, a final court date, and get the divorce. Now, another common myth is he must always pay me alimony. In Texas, we call that maintenance. And that's just not the case. It is not gender specific. The thoughts of that and the law that concerns only one spouse based on gender could receive after divorce payments is simply not the law in this state and at this time in any other state. What that award is based upon are the minimum basic needs that someone has, and can they afford to make those minimum payments to allow them to survive, house payments, gas, electricity, things of that nature for a short period of time. A long time ago, those after divorce payments, what other states call alimony, those could survive until that spouse passed away or that spouse remarried. Now, maintenance in Texas, it has a short lifespan. It's based on a number of factors, but the most important factors, those minimum basic needs. Now, another common myth that I come across many times is the other party must pay my attorney's fees. I'll have my own clients ask, can we force them to pay my attorney's fees? Or the other party will ask my client to pay. No, that is a rare thing. That is something that usually comes in the way of spousal support during the pendency of the divorce, where there is such a difference in income that one party simply cannot preserve the integrity of the community property estate and fight for their community rights, or the children need protection by my party or the other party's participation, full participation in the divorce process, because this evidence needs to be before the judge, that the judge will say, here's some legal fees based on a number of factors, and that's the interim award. On the final court, they're really looking, final court date, they're really looking at somebody who's abused the process, things of that nature. So no, the chance of having that as a final award is rare. The last one that I'll discuss today, and again, these are just a few of many, I think it's 7 that we're talking about now, is the future ex-spouse. The future ex-spouse's significant other can never have a relationship with my child. Well, that's not the case in Texas. And to kind of expand upon that, some parties believe if the biological parent is not personally present, then that child should automatically come back to the other parent's home. No, when that child is with one parent for that visitation period, or that's where domicile resides, then that parent can direct that child to stay with a new significant other, a new spouse, while they go to work, while they take a trip for work, or they take a short trip for vacation. If it's a new spouse and that new spouse decides that they want to take that child with other children on a field trip, a extracurricular activity, sports, they can. They can have that relationship at the direction of the biological parent. Now, those are just a few of the many common myths we deal with. Again, though, every situation is different. If you have a family law matter, or if you'd like to discuss an upcoming filing of divorce, or your spouse has filed for divorce, please contact me, come in for a consultation, and let's talk about your unique facts. And let's develop a plan that allows you to have a loving relationship with your children and the fresh start you deserve. Thank you.